We thank you for choosing TV47 to inform you on sign language interpretation. Tonight is Irene Chebiwot. My name is George Maringa. Thank you for joining us. We'll be having that conversation on State of the Nation with Professor Peter Kagwanja and Professor Macharia Munene in a short while. A recent decision by a three-judge bench of the High Court that maintained the Deputy Chief Justice's DCJ power to form judicial benches has been appealed by impeached Deputy President Rigathi Gachagua, and his application contesting the DCJ's role in selecting the panel overseeing his case was overturned by the bench made up of Justices Eric Ogola, Anthony Mrima and Freda Mugambi. And as Mike Kagwongo reports, the state's challenge against the conservatory orders that prevented Deputy President-elect Kithure Kindiki from being sworn in is set to be heard by the bench on Tuesday morning. Take a look.
The matter of Deputy President Rigathi Gachagua's impeachment process is yet to be settled after the second-in-command sought the intervention of a higher court, the Court of Appeal. Represented by Kamodho Jomo and company advocates, Gachagua's legal team sought an urgent intervention to stay proceedings before the High Court in order to preserve the integrity of their client's rights to a fair trial. After deciding to uphold the bench's constitution, the High Court bench also ordered the continuation of the outstanding applications pertaining to Gachagua's case. According to his application, the ruling was wrong, mistaken, erroneous, and not only based on a grave misinterpretation of Article 165(4) of the Constitution, but also on a wrong analysis of the letter and spirit of the Constitution. However, the state's challenge against the conservatory orders that prevented Deputy President-elect Kithure Kindiki from being sworn in is set to be heard by the bench on Tuesday morning. His next views can be paraphrased as such that the applicant argues that if the bench continues to hear the current applications, it will make the main appeal against the ruling pointless. This is because any decisions or orders made by the bench will be permanent and against the Constitution. He said the orders being sought seek to protect the applicant's inviolable right to fair hearing under Article 50 of the Constitution and to prevent continued violation of the Constitution. Mike Kagwongo, TV47, Nairobi.